Of course, the code has also caught the attention of European leaders because it is critical for the EU's competitiveness and for the growth of European companies. And in my view, ensuring that the code of practice delivers clarity for companies and aligns with the European ambitions to be more competitive will be really an important stress test.
Welcome, everyone, to the AI Governance Podcast, where we discuss practical approaches for responsible AI practitioners. My name is Shankar, and today we're excited to have with us Boniface de Champris. Boniface is an expert on the AI Act based in Brussels and follows these issues closely as a senior manager at CCIA Europe, a nonprofit trade association promoting open markets, open systems, and open networks. So Boniface, welcome.
Hi, Var. Hi, everyone. Thank you for the invitation.
So today's topic is the EU AI Act. And regardless of the Act's merits, it has democratic legitimacy and will apply in a region with a large integrated market. So it's something that all global companies will have to grapple with. So I'd love to get into a little bit of detail about the Act and start at the beginning. So could you describe briefly, how the Act was drafted, how it evolved in response to kind of recent developments in AI, like large language models, and where it stands today?
Great. Well, the AI Act was presented in 2021 by the European Commission. So long before, I would say, the release of ChatGPT and the broader public and regulatory attention around LLMs and generative AI systems. The initial proposal really focused on AI applications and not so much on the technology behind the different use cases. This is something that industry in general has very strongly supported because it is usually the use of a technology that's where risks might materialize. So beyond its what we would call a technology neutral approach, the AI Act also follows a risk-based approach by classifying AI applications in different risk tiers, subject to more or less stringent rules. Certain systems are banned altogether. This applies, for example, to harmful manipulative systems or social scoring systems, and a broad range of AI applications classify as high risk. So this applies typically to AI systems used in education, employment, or public services and law enforcement, but also in regulated sectors. I'm thinking here, for example, of healthcare, aviation, or automotive. So all these high-risk applications are subject to strict requirements, ranging from technical documentation to risk management, human oversight, data governance requirements, but also robustness and cybersecurity requirements. So quite a broad range of obligations here as well. Late in the process, and this corresponds to the release and wide of ChatGPT and then wide adoption by the public of generative AI tools. So relatively late in the process, EU lawmakers added a new chapter on so-called general purpose AI models, which are models that are able to power a broad range of different applications, downstream applications, including generative AI systems. So the rules apply to the foundational model layer, for example, to OpenAI's GPT-4 or to Mistral AI's Mistral large model. An important distinction here is that ChatGPT or Mistral AI's chatbot, which is called Le Chat. They are AI systems and not models. So the models power different systems, including chatbots and different applications and interfaces. The rules, unfortunately, have been rushed in Europe and are imperfect in nature, especially when it comes to the general purpose AI model rules. The AI Act introduces transparency and copyright related rules for all general purpose AI models, but also an additional risk assessment and mitigation requirement, as well as cybersecurity requirements for models that are deemed to pose systemic risks. And these are models that have been trained using more than 10 to 25 floating point operations per second, flops, which is used to measure computing power. So all models above this training threshold, compute thresholds, are deemed to pose systemic risks and are subject to stricter rules. I won't go into the threshold too much, but it is also questionable. And this was also the result, I would say, of rushed negotiations.
Great. Well, yeah.
Well,
I know, really appreciate you setting out that background and just, the draft of the text, the draft text of the Act evolved quickly kind of to incorporate generative AI considerations, and then that text kind of became final. So today, even though the Act has entered into force, companies are closely watching two sources for further guidance. So on the general purpose AI front, the EU AI Office's coordination of the codes of practice that often relate to the most powerful AI systems, like the Code of Practice for providers of general purpose AI systems, is one of those. And you mentioned some of those providers. And then the other is the European Standardization Organization's Sensenelec, which will publish harmonized standards for high-risk AI systems. And just in terms of timelines here, the Act's requirements for general purpose AI providers come into effect this August, that is August 2025, while the requirements for high-risk AI systems come into effect next August. That's August 2026. So let's chat a bit about the role of the EU AI Office. What is its mandate? Why do we hear from commentators that it is understaffed? And how does it interact with working groups in drafting these codes of practice?
Well, that's an excellent question. So the AI Office has been created by the AI Act and is now a department within the EU Commission, but it's still a very recent department. I would say they are not even 1 year old, so it's still very recent. They have a very crucial and also very challenging role in the AI Act's implementation and in the enforcement. So on the one hand, they are responsible for the smooth and uniform implementation and application of the Act. This includes releasing a broad range of guidelines to help companies understand and apply the rules. A first set of guidelines was released in February this year. So on the AI system definition, what is an AI system and what's not an AI system, and then on the prohibited practices under the AI Act. More guidelines are expected, including on fine-tuning, so on how you adapt a general purpose AI model. This is expected before August this year. And then very importantly, also guidelines on high-risk use cases. So what is high risk and what is not high risk, to provide more certainty to companies willing to develop systems. But on the other hand, the AI Office is also an enforcer. It has exclusive powers to enforce the GPAI model rules with very broad enforcement powers, ranging, of course, from requesting information on a given model or any information to assess compliance with the rules, but they can also conduct themselves evaluations of general-purpose AI models that are currently on the market. And it can also issue fines of up to 3% of the provider's annual turnover in case of non-compliance. So they really have a broad range of tasks, and they have been created in May 2024, and are expected to have around 140 staff, including administrative assistants, lawyers, policy experts, etc., by the end of the year, which is, given the number of tasks it has to perform, a relatively low number. In comparison, the UK AI Safety or AI Security Institute has no enforcement powers and a much narrower mandate and also geographical scope, but they already employ over 150 staff. So that's I think interesting in terms of comparison. As for the interaction of the AI office with the working groups, so the AI office appointed independent expert to lead the drafting of the code of practice for providers of general purpose AI model. And it has mainly a facilitator role, at least as we speak. So the chairs and vice chairs have a lot of room to draft the code together with stakeholders. But ultimately, the AI office will need to assess the final code and also formally adopt it together with EU member states. And so they will have the final word, so to say, on the code. And so obviously they are also in very close contact and collaboration with the independent experts that they have appointed. So the code is currently being drafted and needs to be ready in May of this year, ahead of the GPAI model rules entry into application in August of this year. And while the code remains purely voluntary, as providers can use any other mean to demonstrate compliance, it is also critical because companies can adhere to the code, and if they do, demonstrate compliance through this code. And so this will help them, comply and give and provide them with a lot of legal certainty that they currently do not have because the rules are not very clear in the AI Act itself. So the code is really a very useful compliance tool, or should be, if it's designed and drafted correctly. So the code will really apply to the providers of general purpose AI models, but of course it has also an impact on those using the models who want to know that the models are compliant. And it is currently a bit unclear if you take a model from OpenAI or Mistral AI and adapt it to your own needs, which we usually refer to as fine-tuning, then you are subject to at least some of the obligations, and there the Commission will provide guidelines very soon. Of course, this will have a huge impact on the scope of the rules and on the code.
We now have a copy of the third draft of the GPAI Code of Practice, which is the last draft that's going to be made public before we see a final published copy. And it's changed quite a bit since the second draft. So I'm wondering if you can share a bit about the politics behind the scenes of what's happening between the drafts. What are the roles of the companies that are GPAI providers, of civil society, of the European political leaders, and the views of the new US administration, which we saw kind of articulated by JD Vance at the Paris AI Action Summit earlier this year. how are all of these different forces playing out behind the scenes to impact and shape the draft?
Thanks. Well, the drafting of this code has been a marathon, I would say, for everyone involved. And I must say that the overall process has been, well, not really ideal, not at all. So the process was pretty much imbalanced from the outset because we had around 1,000 stakeholders participating in the process, and only a very comparatively very small number of general purpose AI developers who represent only 4% of all stakeholders involved in the drafting. This has caused a lot of problematic issues because obviously the developers know the technology best on the one hand, but they are also those who will ultimately need to apply the rules and adhere to the code if they want to adhere to it. So this created an imbalance and has really had an impact on the process. And then the timeline is extremely short and unprecedented for such an ambitious exercise because the final code needs to be or is due in May of this year and only started towards the beginning of November. So only a few months time to draft such a code. Since the code quickly started to fundamentally depart from the AI Act by introducing a broad range of measures that were already rejected during the AI Act legislative process or were completely outside of the scope of the AI Act. I'm thinking here of mandatory third-party assessment requirements before market placement. All this has raised serious concerns, and the third draft published last week actually still raises numerous challenges, and I'm happy to discuss them in a bit. Of course, the code has also caught the attention of European leaders because it is critical for the EU's competitiveness and for the growth of European companies. So the clearer and workable the code is, the more companies will be able to focus on innovating and attracting funding and investments. And so the AI Action Summit has focused a lot, I would say a lot more, on boosting innovation, on AI adoption, on investments in Europe. And in my view, ensuring that the code of practice delivers clarity for companies and aligns with the European ambitions to be more competitive will be really an important stress test. We need to see that the words are followed by concrete actions, and the code of practice will be one of these examples, I hope. Last but not least, I think it's really important to stress that concerns about the AI Act, so really from its outset, so not only during the implementation, but also during the legislative process, have been expressed by various governments, including first and foremost EU member states, including France, Germany, and Italy, but also the previous US administration, so throughout the entire process. So I don't see anything new on the horizon in that sense. And it really now is on the Commission to deliver.
Great. So you mentioned some of the kind of changes and challenges that you see in how in even the third draft of the code. I'd love to dive into those. So, what are some of the areas that you feel the code is going beyond the Act's requirements? And do you feel that, how do you feel that these are going to become resolved in the short timeline that we have? My understanding is that the May deadline is kind of unlikely to be met. and that we maybe kind of late May and early June, in the best case scenario, we might see a final draft. But I guess two specific questions for you. What happens if we can't reach a consensus and the publication is delayed beyond so into the summer? And then also would love to kind of jump into some of the challenges that you see with the current text.
Great. So indeed, the process has been delayed mainly because, unfortunately, the previous iterations of the drafts were not aligned with the AI Act in the first place, and so this has required more work, and more work is still needed actually to achieve this. So having a code that is well balanced and workable, but also aligned with the AI Act and sufficiently flexible to cope with rapid technological progress in this space is really important. And the AI Act should be the North Star for comparing, a draft, the code, and the actual obligations. In terms of concerns, so the third draft is a bit closer to the AI Act, but we still identify significant issues across the copyright, transparency, risk assessment, and governance requirements, including still measures that are not supported by the AI Act. So I can cite a few examples on copyright, for example. An important concern relates to the obligation to comply with work-based rights reservation protocols expressed through asset or location-based metadata following a cross-industry process facilitated at EU level. First, these protocols, at least as we speak, are not workable in practice. There is no way to comply with this kind of protocols, technically comply with this kind of protocols. But then another problem here is having a European standardization process would considerably undermine global efforts in this space. And so the risk is having permanent regional fragmentation of standards if we have an entirely new standard emerging in Europe. And of course, this could also conflict with international standards that will emerge in this space. So this is typically one of the concerns we have. On the transparency part, the code characterizes personal data as unsuitable data for AI training, which is problematic because it is very often essential to develop language understanding capabilities. And of course, in the safety and security part, we now face entirely new definitions of open source, which never appeared neither in previous drafts or have been discussed before, together with broad risk categories such as harmful manipulation, which in our perspective is not well addressed at the model level, but rather down the line, depending on the use case. And more generally, there are many burdensome measures, especially regarding how you conduct risk assessments, evaluations, mitigations, and reporting. So still a lot of work to do in this respect. And we have also more concerns on the mandatory external assessment part of the code.
Okay. So I know that we're not in the business of prediction, but if you were to predict how the code of practice is going to evolve by the time it's published, what would your best guess be?
So it's indeed a bit hard to say, but I think that European leaders have started to understand how important this code is for companies and for the EU's competitiveness. So at the Paris AI Action Summit, EU Commissioner for Tech, Hanna Virkkunen, called for an innovation-friendly implementation of the Act and also for a code that is aligned with the AI Act. So these are positive signs. The Commission is also pursuing currently the objective of simplifying rules and making sure that companies can more easily navigate the complex landscape of EU laws. And I really believe that the Code of Practice presents a real opportunity to start delivering on these objectives. And so getting this code right is really important, and European leaders, I think, understand this very well now. And so what it means is that, well, while the latest iteration of the code still raises significant concerns, it is not too late to address them. We still have time, and I'm confident that they can be improved to deliver robust and workable code that is also sufficiently flexible to provide a framework for GPAI model development and deployment in the EU.
Great. And looking forward to seeing how that conversation develops. So we've kind of focused our discussion here on the GPAI Code of Practice. I'm wondering quickly whether you can share a view on how well the other process for developing harmonized standards at Sensenelec is going, and when we might expect standards for high-risk systems to be published.
So very, very important indeed. I'm no standardization expert, but what we hear and understand from the ground is that unfortunately, we can expect significant delays in this standardization process. It is unfortunate because once available, harmonized standards will grant a legal presumption of conformity to AI systems developed in accordance with the harmonized standards. So having them available as soon as possible is really key. The Commission has already released one standardization request before actually the adoption of the Act in May 2023. But discussions are not advancing as fast as they should. And as a result, harmonized standards are unlikely to be available before the entry into application of the high-risk rules in August 2026. So we can expect delays there, very, very likely. And we are still also waiting an updated standardization request from the Commission, which will cover, well, changes that happened during the last mile of the legislative process. And should cover, most importantly, also GPAI model rules. So there will be standards there as well, but it will take a lot more time.
Great. So we're almost at time here, but I'd love to chat briefly about the Brussels effect. So this is the concept of the EU setting a standard and other governments around the world kind of adopting that standard. And we saw this with GDPR, setting the global standard for privacy legislation, and then others around the world in different forms, including many American states, following suit and continuing to follow suit. In the case of AI legislation, something similar is already happening in the US, with Colorado already having adopted an AI Act, and other states similar bills making their way through other state legislatures. These bills are typically less rigorous than the AI Act, but they do use many of its key concepts, like having AI system as the regulated entity, the distinction between developers and deployers, the concept of maintaining an AI inventory, identifying high-risk systems, and then conducting impact assessments at some frequency based on the risk level. So have we seen this pattern before in terms of the Brussels effect? And is the AI Act setting the global standard despite the concerns that we hear from some American companies and the US administration?
I think that's always a very interesting question, and it's always a bit difficult to assess But many concepts in the AI Act actually originate from great work that has been conducted in multilateral organizations, for example, the OECD, which has done tremendous work in this space, but also the G7 Hiroshima process, for example. So the AI system definition in the AI Act closely aligns with the OECD definition, which is something we have strongly supported. If we look, for example, at the developer-deployer distinction in the AI Act, it was introduced rather late in the process in an effort to align the Act with international terminology or, terminology that is recognized at international level. So I think many of the basic key principles and concepts in the AI Act can be found in other jurisdictions and in many other laws. Simply, they already have been agreed upon at multilateral level and are based on a lot of work that has been already conducted in this area. Regarding the Brussels effect of the Act, I would be rather cautious because beyond the principles and basic concepts, other jurisdictions have mostly adopted different approaches to regulation, often adopting a more cautious approach to regulation and mostly focusing on equipping regulators with the necessary expertise to deal with AI in their specific sectors. And also the vast majority of the AI Act still remains to be implemented. And companies, at least in Europe, face a lot of legal uncertainty, which currently still surrounds the regulation. So, copy-pasting the AI Act certainly is not something I would recommend. Whether this will happen, I think it's a bit too early to say. And while I'm sure we will continue to see a lot of regulatory attention in other jurisdictions around AI, the real focus should be on creating the conditions for an AI market that can innovate, create, and ultimately benefit society and our economies. And so this has been lacking, at least in Europe so far, and the EU is now starting to really focus on creating these conditions, and is actually already announcing or hinting at a simplification effort that could involve the AI Act and AI rules. So I think it's reasonable to be cautious about any Brussels effects of the AI Act, at least in the medium term.
Great. Thank you. And also an excellent reminder that policymakers have benefited from the tremendous work that the OECD, the G7, and that researchers have been doing over the years. So we're going to have to leave it there. Thank you so much, Boniface, for joining and for that deep dive into the AI Act and the GPAI Code of Practice.
Thank you, Val. Really nice conversation.
Yeah, and with that, we'll wrap up this episode of the AI Governance Podcast. And thank you, everybody, for listening. We will see you next time.